everybody, today I'm going to talk about the Bhopal gas leakage case that took place in India. The Bhopal gas incident, which happened on 3rd of December 1984, is one of the most famous and disastrous incidents that took place in industrial world. And it was caused due to leakage of poisonous gas which is called methyl isocyanate, causing the death of more than 2,500 of people, which made more than 17,000 of people handicapped and 30,000 of people were partially handicapped. Talking about the environmental issue, it caused land pollution, air pollution, water pollution, and also affected the whole human race around the area. Now, talking about the legal issues. Indian government filed a case in the District Court of America against Union Carbide Corporation and claimed $3.3 billion in 1985. However, the case was dismissed on the ground of forum non-convenience. Then, the case was filed in the District Court of Bhopal, and the court awarded with 350 crores of interim payment, which was again appealed in High Court, and High Court decreased the amount by 30%. Then the case was taken to the Supreme Court. A 5-judge bench of Supreme Court gave the verdict against UCC and provided with the compensation of 470 million US dollars. And the remedy was given pursuant to Article 137 of Indian Constitution. Now, after the decision, let's talk about the legal issues. One of the most important legal issue that was dealt by this case was of absolute liability. Though the principle of absolute liability was propounded in MC Mehta's case, but the liability, this principle was introduced through this case only. And it advocates that even if there is no negligence on the part of owner and the incident occurs or accident happens, they can be made liable for the accident. So under the periphery of whole absolute liability, this case comes. And another legal issue that has been dealt is the issue of forum non-convenience. We need to know about this theory while studying international law or private international law, and this says that US court dismissed the case in American court on the basis of that this US court viewed this case can be dealt more appropriately by Indian court for the reason that evidence can be brought easily in Indian court than American court. Now let's talk about the output of the court. One of the most important output, as discussed earlier, is absolute liability with no principle that with no exception was introduced in this case. At the same time, the government of India was made more responsible towards having a mechanism to compensate the victim of accidents. At the same time, acts like Public Liability Insurance Act and Environment Protection Act, these were formulated after this case. At the same time, establishment of National Environment Tribunal in 1995 happened because of this case. And at the end, in 1994, Environment Impact Assessment Notification was passed due to this case, which made it compulsory for the industries to go through impact assessment before establishing, which is one of the landmark thing in environment law and protection of environment. Now, while talking about the conclusion of this case, we can say that yes, this case has been landmark when we talk about enriching the Indian jurisprudence, because it gave Indian government a gist to initiate or to formulate a mechanism so that environment law can be made more stronger. And at the same time, this Supreme Court has been so proactive that it introduced the principle of absolute liability when it comes to accidents and when it comes to compensating the victims of accidents. So yes, this case has been a call for the Indian government to make its governance stronger and protect the environment, and at the same time make multinational companies, industries, factories, owner of these companies liable even for the accident which happens even if precautions are taken. Thank you so much. Hope you liked it.